Okay, let's get started. I'm Jeff Powell, and on behalf of Professor Neil Siegel and the Duke Program in Public Law, it is my genuine pleasure and honor to introduce today's speaker. Tristan Duncan is not a stranger to Duke. She graduated from Duke as an undergraduate and, in fact, has a son here as an undergraduate right at the moment. She did her legal study at Iowa and Yale, and she went back to the Midwest, where she is now a partner at Shook, Hardy and Bacon, and in fact is lead partner in energy law and does complex civil litigation of all sorts. Tristan has always had, since she was a law student, a deep interest in public law and in the role of public law in the life of the American Republic. And one of the things I both admire and marvel about at her is her ability to build what is a wildly successful practice. I will not embarrass her by reading the list of honors and awards and recognitions, although I am going to embarrass her in a moment by reading a couple of quotes. But she's managed to do this while having an active and important role in public law. She's co-counsel repeatedly with Professor Larry Tribe of Harvard, who is by any standards, one of the great constitutional lawyers of our day, and by many standards, the preeminent one. And in that regard, let me read you just a couple of things that Professor Tribe has to say about our speaker. Tristan possesses in great abundance all of the lawyerly skills one would want in the recipient of an award. She writes with grace and force, reasons with a razor-fine mind, excels in legal research, is a persuasive and accomplished oral advocate, has a wonderful strategic and procedural sense, and is a marvel at client relations. You better walk on water. She's done amazing things. Professor Tribe goes on to say that she is truly a lawyer's lawyer in the best sense of that term. And one more quote. Another person who knows Tristan's work well describes her as brilliant, persuasive, and committed to strengthening the rule of law in our nation. It's a very great privilege to have Tristan here. I hope you'll join me in welcoming Kirk.
Thank you so much, Professor Powell, for that kind introduction. I'm actually thrilled to be back at my alma mater and to see such exciting things that both the university and law school are doing to keep Duke at the vanguard of academic thought and public law leadership. In thinking about what I wanted to discuss with you today, I couldn't help but be reminded of my own graduation from this outstanding school almost 40 years ago, and in particular, a graduation gift I had received from my father. With your indulgence, I want to read some of what he wrote, because it helps explain the title of my presentation, When Failure is Success in Constitutional Litigation, Tales from the Trenches with Kurt Vonnegut and Other American Icons, and situates my involvement in the school finance case, Petrella versus Brownback, against the backdrop of Duke and my father's advice upon my graduation, though I didn't fully appreciate at the time how wise his words would turn out to be. But during the course of my remarks, I hope to not only share with you some of the lessons learned from this fascinating constitutional challenge, but also to use that discussion as a springboard to pose some questions regarding legal reasoning and judicial decision-making, and invite you to teach me how to best think about the tough questions that this important case poses. So far, while we've had some successes in the litigation, which I'll explain, we recently lost our effort to persuade the 10th Circuit Court of Appeals to recognize certain fundamental rights and apply strict scrutiny. So we've been returned to the district court for a trial on the merits of our equal protection claim under the lower deferential rational basis standard of review. So the case is currently stayed pending some decisions from the Kansas Supreme Court and a revamping of some of the school finance statutes by the Kansas legislature. Therefore, during the hiatus in the case, I welcome the opportunity to pause and reflect on where we've been, where we're headed, and to invite you to advise me on what resonates with you and doesn't, and if our roles were reversed, how you would lead the litigation strategy. Finally, I will conclude my remarks with the lessons I've learned over the course of my career in building a constitutional law practice, which includes a pro bono practice, the ups and downs and the tricks and traps. And through it all, I want to share with you a few war stories, a few tales from the trenches, if you will, regarding some of the wonderful and indeed iconic figures with whom I've had the privilege to work in this public interest litigation, who have made the journey the highlight of my career so far. While this particular case is not yet a victory and has suffered some defeats, and so far has less to show of it in terms of traditional measures of success, it is the one to date that I am the most proud of. Indeed, it is that very question that I hope to explore with you over the course of the next 45 minutes. What do we mean when we talk about success versus failure in constitutional litigation? And to address that question, I want to go back to May 1st, 1984, the day of my graduation from Duke University. On that day, my father wrote me a letter, and it said, "Dear Tris, I'm advised by your mother that in lieu of a gift or cash as a graduation present, you would prefer a few words of inspiration from us. Money is easier," he said. "Nonetheless, I'll give it a try. It is fitting, I suppose, for each dad to wish his children success when they outgrow the sheltered freedom of adolescence and the sequestered routines of academia, and it is also fitting for him to share at that time the personal formula which has presumably already made the father successful, or if it has not, to recommend that alternative formula which he would adopt were he given a second chance. I'm surprised to discover, however, now that it is actually my turn, I hope you have sufficient failure. You see, it's absolutely impossible to have gratifying success, the kind that comes from shooting for goals a little beyond yourself, without taking some risks. But if you take such risks, and I think you should, eventually you're going to fail and experience some pain. Unless you can be content with safe but tiny successes, you will almost certainly have some painful spills. You should therefore acknowledge that some failure is an inevitable part of a full life and should make sure you know how to fail correctly. These are Dad's rules of failure. Rule 1, never attempt anything that you know at the outset is petty, shameful, or malicious. Rule 2, if you fail in an honest enterprise, always forgive yourself. That's difficult to do if you've already broken Rule 1. Rule 3, just don't forgive yourself, congratulate yourself for reaching beyond your grasp. How else can your grasp be measured? Rule 4, never suffer failure alone. People who only share the good times are just companions, not friends. He concluded the letter with this final advice. So someday, when one of your best efforts is blown up in your face, when it appears that you've really botched it big, give me a kind thought and say, "Okay, Dad, that one's for you." After reading those words, you might have thought that I would have embarked on a risk-seeking career with entrepreneurial zeal. But alas, I'm a little embarrassed to say I didn't. I pretty much played it safe. I went to law school, graduated, returned home to practice law. I joined a large corporate law firm, got married, had 2 kids, and worked hard to develop an energy law practice. I am currently co-chair of both our energy law practice group and now our constitutional law group. It wasn't until 2004, almost 20 years later, after my father wrote his graduation letter, that I finally took Dad's advice and decided to take a very risky case. By that time, my kids were in elementary school at the local neighborhood public school, and we loved that little school. It had all that you would want in a neighborhood school. It was walkable, the kids could walk or ride their bikes, the neighbors watched out for each other's kids, the parents supported the teachers, and the community supported its public schools. At the time, my youngest was in 2nd grade, but between the 1st and 2nd grade, the state of Kansas had a funding crisis and announced dramatic slashes to local school budgets, which in turn caused the termination of teachers and increases in class sizes. At a school event, parents and neighbors started talking about the impacts of the budget cuts in the classroom. We had all noticed that the quality of the education had gone down with the increase in class size. We also were dismayed by the proposal to cut foreign language teachers due to the budget cuts. And we got to talking about what we could do to help. We asked, how much money are we talking? How much do we need in order to hire both the foreign language teachers and enough core curriculum teachers to return to the lower class sizes? Through our local parent-teacher association, we organized a meeting with school officials to ask them what we could do to help and to deploy a grassroots effort to raise the necessary funding to offset the budget cuts. It was participatory democracy at its finest. It was in this moment, in fact, that I thought, so this is what civic virtue actually feels like. I had studied political philosophy with Professor Gillespie in Duke's political science department and with the fantastic Professor Powell in law school. I even had written an entire paper on it, on civic republicanism and civic virtue and the proper locus of it in our society. But to be frank, I had never really experienced it firsthand, but now I was. Therefore, when Justice Kennedy recently described federalism values in Bond versus the United States, oops, what did I do? In which he describes federalism as allowing local policies more sensitive to the diverse needs of a heterogeneous society, permitting innovation and experimentation, enabling greater citizen involvement in democratic processes, it took on a new meaning. Prior to that time, federalism values sounded nice in theory, but the reality was state government, state officials, and the state capital, for me, Topeka, Kansas, were all about as geographically and functionally remote as a practical matter as Washington, D.C. was. So when Justice Kennedy described in Bond that federalism allows states to respond to the initiative of those who seek a voice in shaping the destiny of their own times, without having to rely solely upon the political processes that control a remote central power, I thought to myself, that might have been true at the founding when states were geographically and demographically smaller, but is that really true today? After all, some states like California are larger than many nations. In contrast, here we were, as a community, meeting at the local gym with our local school officials, talking about what we could do as a local community to be responsive to our local school needs, to take care of all of our neighborhood kids, not just our own through private tutors or private donations, but as a community who cared about and wanted to be associated ideologically with our public schools. But while I was reveling in all this participatory democracy, I was thunderstruck, I tell you, by the response we received to the most American of questions, asking not what the government could do for us, but as John F. Kennedy once urged the nation, what we could do for it. And when we met with the school officials and asked them what we could do, their response was nothing. We could not do anything meaningful. We had to stand down and would have to be satisfied and just stuck with the bad situation. Oh, sure, we could do bake sales and fun runs to raise a paltry few $1,000s here or there, but we couldn't do anything meaningful to raise the millions needed for the following school year to avert the budget crisis. It was estimated that the funding crisis could be averted for approximately $25, something like that, per household. Why were we stuck? Because, and I kid you not, this is exactly what the school officials said, it was illegal to spend more money on your kids' education even if we voted to increase it, even if every citizen in the entire district unanimously approved a spending increase, it was illegal. Why? Because of the thing called the cap on the local option budget. The local option budget is basically legal jargon for the ability of citizens within a local school district to raise additional money locally to supplement the level of funding that the state distributes to all the districts in the state. In plain speak, the cap on the local option budget was a spending cap, a ceiling on spending any money on public education above a certain level. In that moment, when I heard that response, that you cannot do anything to help, I said to myself, that cannot be right. That cannot be constitutional. This isn't Soviet Russia. This is America. In America, surely willing citizens have the freedom, the personal and political liberty to spend their own money voluntarily and collectively on their own local public schools when doing so doesn't hurt anyone else and when the state is in a budget crisis and needs the money. Isn't this the perfect example of John Locke's no harm principle? Nobody is hurt if we spend more on education. We aren't taking a penny from any other district. All other districts will receive whatever amount the state allocates to them or that they raise themselves. So how can more education be dangerous? Isn't that some form of censorship? Isn't the state essentially restraining the people's acquisition of knowledge that they themselves are willing to pay for? Sure, it may not be a content-based restriction, and it obviously is viewpoint neutral, but that shouldn't matter. It does limit the overall quantity of education, the totality of information and ideas that a community otherwise would require for its children. The more I thought about it and the more the community thought about it, the more indignant we became. After the 2004 PTA meeting, I raced back to the office and spent the next couple of days locked in a library researching whether or not spending caps on public education were indeed constitutional. And it was while reading the seminal education rights case, San Antonio School District versus Rodriguez, that I had a Eureka moment. That case has hundreds of footnotes and is a plurality decision, but in footnote 107, yes, the 107th footnote, and I did read all of the 106 prior footnotes with increasing despair, but in footnote 107, the clouds parted and the planets aligned. I found my answer, and the answer was good. Rodriguez itself telegraphed that education spending caps might not be constitutional after all. As many of you will recall from your Common Law 101 class, Rodriguez was the decision from 1973, a plurality decision that held that education is not a fundamental right, and wealth is not a suspect classification. Justice White, however, wrote a dissent, and in that dissent, he hypothesized that what might be a successful equal protection challenge, unlike Rodriguez, which was a funding floor case, Justice White instead forecast that a ceiling might not survive constitutional scrutiny. And he explored the distinction between funding floors versus funding ceilings cases. The best part, though, is that in footnote 107, the majority didn't disagree with him and, in fact, reserved that specific question for another day when it was properly presented. And in this footnote, it basically says, the court said that the majority notes that the appellees do not claim that the ceiling presently bars desired tax increases. Therefore, the constitutionality of that statutory provision is not before us and must await litigation in which it is properly presented. And then it cited a federal Florida district court case, Kirk v. Hargrave. This was the Eureka moment because even though the Edgewood, Texas district didn't involve citizens who desired to voluntarily raise their taxes to achieve equality with better funded districts in the state, these Kansas citizens in the Shawnee Mission School District did. So immediately I read Kurt v. Hargrave and discovered the exact holding I was looking for. A 3-judge federal panel had declared a nearly identical education spending cap unconstitutional, stating, the legislature says to a county, you may not raise your own taxes to improve your own school system, even though that is what the voters of your county want to do. We have searched in vain being the operative part of that sentence, for some legitimate state end for the discriminatory treatment. The case had lots of other good language and reasoning to justify its conclusion that the education spending cap was unconstitutional. So after reading footnote 107 and Kurt v. Hargrave, I basically looked to my left and I looked to my right and I said, why isn't anyone arguing this? This is great stuff. So I went back to the PTA meeting, told the group I thought we had a case after all, but didn't want to proceed unless I had the support of both the school district and the community. And in one of the most memorable moments of my career, I was met with resounding applause and a rush to the podium to sign up. So at that time, in 2004 and 2005, another school's case was already pending in the Kansas state courts. It was Montoy. Therefore, we decided to instead file an amicus brief and hope that our criticism of the cap would influence the decision in our school's favor. But because we were trying to influence the school finance litigation when it was already pending before the state's highest court, and without our ability to develop the facts or the expert testimony in the lower courts, I faced a conundrum. How to convince the court of the wrongness, the absolute oppressive quality of this cap. And it was because of this need to communicate the human dimension of our case, not just its doctrinal support, that I asked an associate to find for me a metaphor or an anecdote or a story that captured by analogy what was so wrong with the Kansas education spending cap. And he brought to me Kurt Vonnegut's Harrison Bergeron. If you do not know the short story, then your education is incomplete, and you need to go out forthwith and get a copy and read this timeless literary masterpiece. It's a satirical short story, and it beautifully encapsulates what's so wrong with handicapping excellence as a means to achieve equality. I want to just read a couple excerpts from the story to you. The story starts out by saying the year was 2081, which Vonnegut wrote this in 1961, and I'm a little bit amazed at how quickly 2081 is coming upon us. But anyway, the year was 2081, and everybody was finally equal. They weren't only equal before God and the law, they were equal every which way. Nobody was smarter than anybody else, nobody was better looking than anybody else, nobody was stronger or quicker than anybody else. And all this equality was due to the 211th, 212th, and 213th Amendments to the Constitution, and to the unceasing vigilance of agents of the United States Handicapper General. In Harrison Bergeron, Vonnegut creates a future society in which equality is achieved by literally handicapping people physically, so that nobody is better than anybody else. This government-created equality is enforced by the Handicapper General, an official whose job it is to install the physical handicaps on the talented, skilled, and industrious to ensure universal, unthreatening mediocrity. I want to read for you just one other excerpt in which he kind of captures this idea. And George, while his intelligence was way above normal, had a little mental handicap radio in his ear. He was required by law to wear it at all times. It was tuned to a government transmitter. Every 20 seconds or so, the transmitter would send out some sharp noise to keep people like George from taking unfair advantage of their brains. The Montoya amicus brief drew parallels between the Vonnegut satire and the real-life application of the spending cap to Kansas school children. Just as the cranial handicaps crudely installed in the brain of the gifted young man Harrison Bergeron were intended to diminish his intelligence so that others were less smart by comparison and therefore appeared identical and therefore equal, so the brief argued the education spending cap similarly crippled academic excellence so that public education statewide also perversely appeared identical and therefore equal by comparison. The cap in purpose and effect tried to disadvantage or handicap the education of some who were perceived by the state as just too advantaged in order to advantage others by comparison. In other words, the system doesn't subsidize the education of those needing to be brought up, but instead handicapped those who were perceived as just too far ahead by bringing them down and denying them the educational achievement that additional funding would permit. So we filed the amicus brief and assumed that would be the end of it, until the court ruled, but we were wrong. Many amicus briefs were filed, but the press only reported on one, ours, and it did so in a misleading and shameful way. On the front page of the paper above the fold, the headline read, "Lawyers could use literary lesson." It even said, Vonnegut says attorneys have misinterpreted his story. And what the paper had basically done is that the reporter had called Vonnegut, had paraphrased our argument to him, and had extracted from Vonnegut a quote that we had misinterpreted his story. Well, I was furious. I located and called Vonnegut's agent in New York City and said, "Excuse me, but I think I correctly interpreted Mr. Vonnegut's story, but in the end, I don't really think it matters whose interpretation is correct. Instead, I have a proposition for Mr. Vonnegut and would like to speak to him." Vonnegut's agent said that he'd only speak to me via fax, not directly, but if I would send him a letter regarding what I wanted and attach the amicus brief, then Vonnegut might read it, no promises, and if he was interested, he'd contact me. So I sent my letter, brief, and contact information, and here's what I proposed to Mr. Vonnegut. I said, "I am very much interested in your thoughts on the applicability of Harrison Bergeron to the constitutionality of the Kansas school finance formula, and in particular, one component of that formula, the cap on the local option budget. Should you agree with our interpretation, we will be vindicated, and I will have a delightful conversation with Mr. Rothschild, the reporter who had written the story. Should you disagree, then I have a proposal for you. I propose that you and I engage in a public debate on the proper role of equality and liberty in public education in the Lawrence Journal Ruled by writing either together or separately a letter to the editor. In our letter to the editor, we would invite the court of public opinion to be the judge on whose interpretation is correct. I think our friendly debate could excite the public's imagination, bring much needed attention to the real issues in public education, and demonstrate how the individual can triumph over the state in our modern mass society, irrespective of who wins the debate. I look forward to your response. I assumed once I hit the send button, that would be the end of it. I would never hear from him again, and I would have to suffer the humiliation of this media outrage alone with absolutely no support. But a day or so passed, and I was driving my son to soccer practice when my cell phone rings. And on the other end is this booming voice that says, "Tristan Duncan, this is Kurt Vonnegut." And at that moment, I lost all professional composure, and I started screaming, "Ah!" He said, "I've read your brief. I agree with your interpretation, and I'm honored you've used it. What can I do to help?" I started getting very excited and said, "I'm so glad you called. I absolutely want to talk to you, but I'm on my way to take my son to soccer. Is there any way we can talk in the morning?" And he was very gracious and said, "Sure, give me a call in the morning." But from that point forward, he called me soccer mom. But anyway, that becomes relevant later. I promptly called him the following morning, and he immediately picked up the phone and said, "Oh, thank God you called. I've been up all night. I've got so many ideas." And he immediately started rattling them off. To this day, I have pages of these cornucopia of thoughts from Kurt Vonnegut. And I confess I could not keep up with him, and he was going a mile a minute. But finally, when he stopped, I said, "Love all those ideas, think they're amazing, but do you want to hear my idea?" And there was a pause, and then he said, "Okay, shoot." I said, "So here I am. I'm an attorney who needs to convince the highest court in the state of what is so wrong with this cap. And I have none of the traditional tools by which I usually could persuade a court. None of the traditional authorities for truth are particularly helpful. I haven't had a chance to develop the expert opinions or developed moving factual testimony. I need to appeal to a higher authority, the kind of authority that communicates truth in the way great art speaks the truth. I need to rely on and have the court be persuaded by a great artist, and that artist is you." After a long pause, he said, "Tristan Duncan, will you marry me? I think I love you." Well, I, of course, immediately accepted and told my kids Mom had just gotten a better offer and we were moving to New York. But after we had a good laugh, he decided he'd write up a letter to the editor clarifying the true meaning of Harrison Bergeron and vindicating my interpretation of Harrison Bergeron and its relevance to Kansas education. And here is the letter, the initial letter he sent me. The best part about it is what he wrote at the bottom. He says, "Dear soccer mom, I am Putty in your hands. I await your instruction as to how I could improve this to your advantage." He then mailed this letter to the editor, in which the most salient part is where he says, he basically starts out, "In regard to your May 5th, 2000 piece, Vonnegut's Lawyers Could Lose Literary Lesson, which had to do with my story, Harrison Bergeron, and its involvement in recent litigation. You got it wrong, the attorneys got it right. Your reporter, Scott Rothschild, gave me no clear idea what the case was about, which I now know to be the actions of the legislature as preposterous to me as any lampoon I ever wrote. My story mocks the idea of legally eliminating envy by outlawing excellence, which is precisely what the legislature means to do in the public schools by putting a cap on local spending on them. Should it prevail, it will be possible for me to say there are no longer any truly excellent public schools in all of Kansas. Talk about a level playing field." Now, you'll note that the title of this slide is Unpublished Letter to the Editor, because this lucid and insightful letter regarding the true meaning of Harrison Bergeron was never published. The Lawrence Journal ruled, get this, refused to publish it as Vonnegut had written it. Yet it published other letters to the editor saying the exact opposite, For example, it published one piece saying how pleased the author was to have confirmation that Harrison Bergeron is about egalitarianism. Yet Vonnegut's letter to the editor said essentially the exact opposite. It said, my story mocks the idea of legally eliminating envy by outlawing excellence. This experience with the Lawrence Journal world is itself, I think, an important commentary on the role of the media in public law litigation and how the media can, in disturbing and unaccountable ways, skew public discourse when it exercises such wrong-headed editorial discretion. And I'd love to see more scholarly commentary on that problem. In any event, that was 2005. Although the state Supreme Court ordered additional funding, it did not address the constitutionality of the cap. Oh, and Vonnegut did authorize us to continue to use his letter in our litigation, which we've done. We continue to cite to him even in some of our appellate briefing. But anyway, 5 years went by, and then the other shoe dropped. The second funding crisis hit, even worse than before. In 2010, the budget crisis was a double whammy because not only were we losing teachers and facing even more escalating class sizes, this time with the budget crisis was causing the closure of beloved neighborhood schools. This time we decided to proceed not as amici, but to instead file our own lawsuit. And this is one of the schools that they were planning on closing. And the key facts in the Petrella case are this, that the Shawnee-Mission School District is basically in the bottom 5% of all funding in the state, whether you look at just the state funding or all funding, and it's undisputed. The state admitted that they are in the bottom. It would take actually 50% more funding than they have in order to achieve equality with better funded districts. The voter approval of spending increases was permitted, and there was a statutory mechanism already in place for voter approval for spending increases, so the court would not have to make up out of whole cloth the voting procedures for voter approval of the spending. There was also a suspension on any limits on taxing increases, so it becomes more important later, but this really was a spending cap case. It wasn't truly a tax cap case. In any event, we decided to situate the case not only within Rodriguez footnote 107 and Kirk v. Hargrave, but we also wanted to take advantage of the Roberts Court's First Amendment jurisprudence. In particular, I was intrigued by the idea of using the campaign finance cases as persuasive precedent for declaring education finance spending caps similarly unconstitutional under the Free Speech Clause. Why? Because the reasoning of those cases seemed to squarely apply, more so, in fact. First, because the logic of those cases follows essentially a syllogism. Money spent on speech is speech, therefore caps burdening spending also burdens speech. This logic similarly applied to education caps, but the logic, to me at least, applied even more forcefully because unlike the campaign finance spending caps, there was no concern over corruption or quid pro quo corruption or undermining our representative form of government. Instead, how could anyone complain if community wanted to spend more money on education? So to us, this was a stronger case for that logic, that reasoning, than even the campaign finance cases. And I'll unpack that reasoning in a little bit, but I also wanted you to know there were other aspects of this case that caught our imagination, that situated it at a particular point in time. This particular community and this particular school district basically sat at a crossroads. It sat at a demographic crossroads because while it had previously been primarily a Caucasian type school district, there was this huge increase and this huge influx of minorities, economically disadvantaged, and English language learners, and the community was very welcoming. They were wanting that kind of social diversity. It also sat at a geographic crossroads because to the north or to the south was Topeka, Kansas, where of course Brown versus Board of Education arose, and to our east was the Kansas City, Missouri School District, which is where the also landmark case Jenkins decision occurred. Of course, the Jenkins decision was the decision that dealt with court-ordered tax increases to combat de facto segregation and white flight. It also seemed to sit at a historic crossroads because unlike Jenkins and Seattle schools where you had race-conscious attempts to encourage voluntary integration, this was a case in which the effort was being initiated by the people themselves. So we thought it was sitting at an important time in the development of the jurisprudence. And in fact, in the Jenkins decision, there's a quote from Justice Kennedy in which he says that in that decision, the proper remedy, rather than having a judicially imposed spending cap, would have been for the court to have lifted, the very remedy we were looking for, lifted the spending cap so that the local institutions who were ready, willing, and able, but for the operation of state law curtailing their powers, able to remedy the deprivation of constitutional rights themselves. In addition, we believe this case was rising at a time when there was a potential transition away from some divisive and polarizing affirmative action policies, and at a time when there was more judicial solicitude toward protecting the people's own civic engagement on important public policies. Justice Kennedy's language in the recent Schweddy decision in particular telegraphs some of these themes. Therefore, to us, what made this case extraordinary was not only that it wasn't a funding floor case, but a funding ceiling case, but also it was somewhat extraordinary because it wasn't what we see in politics today, which is a kind of paralysis, a passing a buck, that's somebody else's fault, somebody else needs to be doing it, but instead what we had is a community who is ready, willing, and able to engage in civic self-sacrifice for the betterment of their community's school children's educational needs and to voluntarily help integrate an increasingly diverse student population. But the state of Kansas was stopping them. I just want to show you real quickly, before I move on, that we were captured by the contrast between these two images because in this neighborhood, there were, during the course of this litigation, there had started this movement of erecting these little free libraries, which have sort of popped up all around the nation, but it was, the timing of it was particularly sweet during this litigation. But what you have on the left is a private property owner who is within this very community, dedicating the use of her private property to the free education of the neighborhood kids. And we were struck by the contrast between the two situations, because on the right is the image of the closure of the public school due to the spending cap. We see a no trespassing sign and a chain barring access to the closed school's library, a physical barrier to knowledge, so our modern-day handicap or general. But on the left is the image of the opposite, right? A little free library containing books of all shapes and sizes, neatly stacked with a sign that says anyone coming upon it could take a book, read it, pass it on, and return with another book to replace it. So we have a homeowner dedicating use for private property to the neighborhood's acquisition of knowledge, free public education. And the homeowner used the word free in her sign to mean no payment was required to take a book. But we thought of it in its more broad sense. Unlike the schools at the center of our public spending cap case, this little library is free from governmental interference in a way that the larger library down the street is not. And so we thought this created an interesting contrast between the two situations. Okay, so the doctrines that we deployed in Petrella was equal protection, a substantive due process, and the First Amendment. The other side initially argued that we lacked standing to sue because of the non-severability clause. If the cap was declared unlawful, that would make the entire school finance scheme fall, and with it the statutory basis for the necessary funding. Therefore, the non-severability clause made our claims non-redressable, and that was essentially their argument. Our first trip to the 10th Circuit involved establishing standing, and we won. That was our first victory. But importantly, from that victory, the 10th Circuit framed how they regarded our claim. And they stated, as we have made clear, appellant school children alleged injury while flowing from the spending cap was not the inability of the district to raise unlimited funds, but rather the alleged unequal treatment manifested in, among other things, lower per pupil funding that prevented them from even attempting to level the playing field. And I liked how they picked up on the level playing field imagery that Vonnegut had also used. Now, it's possible that Judge Ebel, who wrote that decision, and it was a unanimous decision by the 10th Circuit, who had been a Justice White clerk, appreciated more than the subsequent Tenth Circuit panel what Justice White had hoped to achieve in his dissent in Rodriguez. Who knows? But in any event, we weren't so fortunate the second time around. The subsequent Tenth Circuit panel rejected our fundamental rights arguments and our request for heightened scrutiny. But I'd like to turn now to just explaining a few of the core arguments and why we think, at least, that the court got it wrong. But even if the court was right in its result, we found the reasoning very superficial and unsatisfactory, and we see it as an increasing incoherence in the fundamental rights and First Amendment context, which would benefit from more scholarly guidance. What we first tried to do was we tried to situate our arguments in the context of how Rodriguez should be distinguished. In other words, the question was which line of precedent should apply. Should the Rodriguez deferential rationality review line of precedent apply, or should the education as speech and money as speech line of precedent apply, which would require heightened scrutiny? And we identified essentially three key ways in which Rodriguez was distinguishable. The first was that in Rodriguez, the plaintiffs were seeking a constitutional minimum amount of funding. So they wanted money from the state. So that was more in the nature of a positive right. In contrast, what we were seeking was to lift an obstacle to the people themselves providing more education. And so ours had more of a negative rights dimension. So here's the particular quote from Rodriguez that makes this point. Let me just read it to you. So I won't read the whole quote, but basically it's saying that we've always protected unjustifiable interference with the right to speak and the right to vote, but what we don't do is guarantee the most effective speech. Who does achieve those goals? The court says these are only goals to be pursued by a people. That would be us. That's what we're trying to do, whose thoughts and beliefs are freed from governmental interference. So we essentially were arguing that the cap was that kind of governmental interference. If it was lifted, we would be free to achieve expressive and communicative type aims. Now, the other distinction we drew was that the reasoning that was employed in Rodriguez was more of an instrumental type analysis. Namely, it made the point that education was not itself a fundamental right, but education was preservative or instrumental to preserving the enumerated rights of freedom of speech and the freedom to vote. But we argued, wait a minute, that doesn't address the predicate question. The predicate question is education itself speech? And the answer seems to be fairly obvious that it is. For example, the dictionary definition of educate is to provide with information and to teach, right? And there's an entire line of precedent, a Supreme Court precedent, that's basically acknowledging that the education context is a very expressive activity and is a traditional source of First Amendment protection. So we didn't think that it was sufficiently distinguishable from that line of precedent. And in fact, what I'm quoting here is the Tenth Circuit's acknowledgement of the rationale of those cases would arguably extend to this case. But they ultimately conclude that this case did not involve speech. So this is just the rationale. Each of these cases recognize that the First Amendment protects speech in the education context. So what ended up being disappointing about the reasoning is that they never engaged the question of, is education speech or isn't it? They just sidestepped it and they just categorically said education is not speech. All right, we also then relied on the Meyer, Pierce, and child rearing and education rights cases. As many of you may know, Meyer is the first case in which the court held that a state ban on teaching foreign languages violated the Due Process Clause. And then Pierce came and held that the state could not mandate public education. It had to permit private education. And importantly, Justice Kennedy has said that even though those were decided in the Lochner era, if they were decided in more recent times, they would be decided, or they might be decided under the First Amendment analysis. So we liked how these parental rights, child-rearing rights, education rights related cases potentially had a nexus with the First Amendment, which would then justify heightened scrutiny. Importantly, though, just this last term, Meyer and Pierce were what the Supreme Court relied on and Justice Kennedy relied on in the Obergefell marriage equality case. And the Supreme Court specifically said a third basis for protecting the right to marry, the court explained, is that it safeguards children and families and thus draws meaning from related rights of child rearing and education. Thus, in Petrella, we argued, is just like the child-rearing, education, and expressive rights cases, and warranted the removal of the state-created obstacle to the plaintiff's educational opportunities. Now, one of the decisions that Obergefell affirmed was the Kitchen versus Herbert decision, which was written by the same judge that wrote the Petrella decision. In Kitchen v. Herbert, Judge Lucerno made a point of saying that these Meyer and Pierce line of cases established what he called a cluster of constitutionally protected choices. But interestingly, even though that was the very heart of what we were arguing for, he took the exact opposite form of reasoning in Petrella and said that what we were arguing, this constellation of rights, which should be extended to Petrella, was more of a kitchen sink argument rather than the kind of argument that supported marriage equality. The question is the difference really tenable? And can it really be reconciled? Now, quickly moving to the campaign and finance cases. Again, campaign finance is heightened scrutiny. The education finance caps right now under the 10th Circuit's reasoning is rationality review. The question is, why the difference? The purpose of the spending cap is very similar to the purpose of the caps in the campaign finance context. The overriding purpose that the state proffered was equity, to help equalize the ability of districts with lower property wealth to raise money through the use of the local option budget. The problem is the cap doesn't actually raise money. It'd be one thing if this was a subsidizing type law. It's not. It ends up limiting money, and it limits it based upon the same rationale that has been rejected in the campaign finance context, namely the concept that the government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment. When it comes to such speech, the guiding principle is freedom, not whatever the state may view as fair. So here I want to take a step back now and look at education finance from the bigger picture, because we've got this anomalous situation going on. Brown stated that if a state is going to provide education, it must do so on equal terms. Well, we clearly don't have that going on. There's gross disparity in funding in the state of Kansas. So then the state Supreme Courts have stepped in with the Gannon and Montoya decisions and have basically said, okay, well, the Constitution doesn't require equal funding, but it does require equitable funding, as if there's a distinction between equality and what's equitable, and what's equitable has to be suitable. So then we go to, well, okay, what does that mean? Well, it's true that the Kansas Constitution does require a suitable level of finance, but the problem is suitable is itself a tautological term. Suitable dictionary definition is appropriate, and that's a question-begging term, because something is appropriate only if you know if it's appropriate with respect to what. So you need a separate standard, and unfortunately, we, the people, are to blame. We, the people, have set up the problem because we have not given language to the justices to allow them to interpret what we really mean. So instead, the Kansas Supreme Court is importing a judicially created equity term into the meaning of suitability. And unfortunately, that equity term is starting to have a handicapping and leveling component. And that leveling and handicapping component, we believe, is starting to be on a collision course with the equity reasoning of the Supreme Court's First Amendment jurisprudence. And I think that cries out for some scholarly treatment. So that's why we've come full circle. That's why I'm here. I was actually amused as we've been noodling on these fascinating issues by Chief Justice Roberts' comment that he made to the Fourth Circuit a while ago, in which he says, pick up a copy of any law review that you see in the first article is likely to be, the influence of Immanuel Kant on evidentiary approaches in 18th century Bulgaria or something, which I'm sure was of great interest to the academic who wrote it, but isn't of much help to the bar. When I heard that, I kind of had to chuckle because when I was in that PTA meeting hearing about how it was illegal to do anything more to help our local education, it wasn't rules of civil procedure and it wasn't the canons of statutory construction I was thinking of. It was Owen Fiss and Anthony Kronman's Tyranny of Kant class at Yale Law School that came to mind, and some of the things that Professor Powell had taught me while in law school. So, by the time this second case rolled around, I decided I wanted some scholarly help. I wanted to bring in someone who would give me a bigger overarching constitutional perspective. And at the time I was working with Professor Tribe on some other cases, and I asked him, would he be interested in helping on the Petrella case, even though I couldn't pay him. And after he read the brief, he said, okay, sign me up. So Professor Tribe has been a co-counsel on the Petrella case, as Professor Powell highlighted, has very much like Kurt Vonnegut, he is terrific and he loves the intellectual give and take. And he has one comment at a event in Kansas City that I want to read to you because I invited him to speak to a bunch of high schoolers in Kansas City on his new book, Uncertain Justice. And at the end, the kids got up and were able to ask questions. And one of the questions that he was asked was, which case he was most proud of. And he said it was one that he had lost. And the one he had lost, of course, was Bowers v. Hardwick. And he has this wonderful statement that he gives. In 1986, a guy named Michael Hardwick had been arrested for intimate activity with his boyfriend, in private, perfectly consenting, and under the laws of Georgia, which was involved at the time. That was a crime. Although I knew that the composition of the court at the time made it hopeless, we could not win a claim that the Constitution prevented Georgia from outlawing certain consensual acts in private. But I also knew that we would likely get a dissent or two, and that those dissents would eventually become the law. So I lost 5-4 in this case called Bowers v. Hardwick in 1986. And I kept telling my students year in and year out, just wait, it won't be too long before the court overrules it. It was a while, 17 years, but in Lawrence v. Texas, the court overruled Bowers, and in Bowers, my focus was, it didn't matter exactly what Michael Hardwick was doing in his bedroom in private. It was nobody's business. The question was, what was Georgia doing in his bedroom? So I'm proudest of that loss, although I'm pretty proud of some of the wins too. So with that, I want to turn now to some of the tricks I've learned over the course of my career on creating a constitutional law practice, and in particular a pro bono practice. And I think the first is to assemble a team, a like-minded team, because it makes it a lot more fun. You spread the work around, and the brainstorming is the best part. I also think it is important to strike a balance between paying and non-paying clients. That's taken a while to develop, and I'd like that for a number of reasons. The first is, obviously you've got to pay the bills, but actually another reason, that is by having a diverse client docket of corporations and individuals and families, it allows you to always be asking yourself, is this a rule, is this a law that's actually going to serve the public interest? It forces you to actually avoid confirmation bias. I have been amazed sometimes at how predisposed you can get to one point of view, whereas if you have a number of different clients, it pushes you to have a more balanced, I think, point of view. It also provides then a springboard for coalition building, because I have had corporations that have ended up being interested in helping out or contributing to some of the pro bono efforts. And in fact, Professor Powell and I were talking about how you do coalition building for those who might be interested in criminal law or poverty law. There's a case that was handed down a while back, the Lafleur v. Cooper case, in which the problems with unfair procedures in plea bargaining context and how coercive that can be. And in particular, poor defendants are particularly vulnerable to being put in a position of bargaining away their constitutional rights. But on the civil and corporate side, in the context of class action settlements, the same sort of coercive procedures can be brought to bear. And there's a number of those of us on the practitioner side who are looking at challenging some of the unfair procedures there. So that can be the kind of thing in which you have different types, clients and different types of law, but would be united in a defense fund or a think tank that would help advance the kinds of reform initiatives that those in the criminal law and the poverty law area could benefit from. But in the end, I think when you are building a constitutional law practice, you can't avoid the risk that sometimes things don't go the way you want them to. Sometimes you've got to be prepared to give up the nice office, you got to take a pay cut, you've got to face being maligned in the press. And when that happens, though, when that failure type thing happens, then give me a kind thought and say, okay, Tristan, that one's for you. Thanks. Any questions?
I've got one. I'll start. I'm really interested in the point about the value to your own thinking of a mixture of different kinds of cases. I mean, one thing that that a couple of people in the room are familiar with is that I always try to make, actually several people in the room are familiar with, I always try to make people think about both sides of an argument. But you're talking about something that's a little different, although related. You're saying that if you've got a mixture of things that you're involved in, different kinds of clients, different kinds of causes, different kinds of areas of law, that helps you from getting stuck intellectually in one particular perspective. It avoids confirmation bias in terms of cognitive functioning. And that's extremely interesting. Do you have any further thoughts about how we can do that? Because
well, the example that comes to mind is, and I'm involved in the Aspen Institute in the Justice and Society program, in which the co-chairs have been someone who typically is more on the corporate defense side versus the plaintiff's side, and I found myself increasingly frustrated when I'm with either my traditional corporate law type defense-oriented colleagues who will always refer to the they or refer to the plaintiff side as skewing the system, in their favor. And because I've been on the opposite side, where I'm also on the plaintiff's or the individual or family side, I've also been with those attorneys who demonize corporations. And I love corporations. I've worked with small corporations, I've worked with large corporations, I've worked with mom and pop entities, and there's good people on both sides. And I think your reasoning and the rule of law requires us to take each litigant and treats them equally, with equal respect. And I think if you don't have in your mind the image of those people who are either in working on a daily basis at the corporation or the individuals and families as people, you tend to, I think, engage in more of a rule of men type analysis rather than a rule of law type analysis.
Can you talk a little bit about strategy? So you have a lot of different arguments in Petrella. How did you figure out which one to lead with? And did you worry about having so many? I mean, did you worry as a strategy matter that maybe you should just pick one and go with that for fear of the court calling you a kitchen sink? I mean, so can you just talk about how you worked through that?
No, that's a great question.
And why you really went with the campaign finance one, because it doesn't seem to fit as well.
Oh, well, I like the campaign finance.
See, that's the interesting thing. When we would talk about it, some people loved the campaign finance one, and other people hated it. And because we did think that this might ultimately have a trajectory to the Supreme Court, and because the Supreme Court can be sometimes all over the map in terms of which arguments they center in on and, take up, we were worried about waiving arguments that we would regret later. And we struggled with, is it, a kitchen sink? But because we were pioneering somewhat new ground, we felt like we had to keep them all because we weren't sure which. For example, in the first oral argument to the 10th Circuit, the arguments I was getting, they had to stay focused on the jurisdictional arguments, but it couldn't help but segue into the merits. And it seemed like I was getting resonance from all three, for both First Amendment and liberty, and even in the second oral argument, one of the judges was like, why aren't you just arguing liberty? This is clearly a political liberty case. Why are you talking about the First Amendment? Education has always been about equal protection. And so, I would have, in some ways, I kind of regret not having mocked it sooner. But it was, and this is maybe something, with pro bono litigation, you do try and do things on a shoestring. And we initially thought we were going to take it up all on a stipulated record, right? All of our facts were very simple. We just had 10 stipulated facts that we then immediately moved for summary judgment. We didn't have a trial other than one short hearing for a preliminary injunction. And we thought, okay, if we can just go up and say, footnote 107, maybe that's all we need to do. And worst comes to worst, we haven't shot ourselves in the foot. We can always come back and do the trial on rationality review. But if we could get the golden ring, namely strict scrutiny, and the recent decisions coming out of the 10th Circuit were beautiful on campaign finance, because they had two decisions in which they said it didn't matter whether you were challenging a spending cap under a First Amendment. So 3 judges on the 10th Circuit liked the First Amendment. The other judges struck down spending caps under an equal protection analysis. And they basically said it didn't matter which way you went, strict scrutiny applied, and they were struck down, and then you got an injunction to lift the cap, and so you didn't even have to look at the other 3 factors for an injunction. They just looked at likelihood of success on the merits. And so we were wanting to say, we want that result. Apply that, and if you apply that, we win. And how is there a, principled basis for distinction? All the while, we were really grappling with, we knew how much people hated campaign finance. And in some ways, I kind of thought to myself, why didn't the Supreme Court take up education spending caps before campaign finance. You know, some people have criticized that they reached out to decide those cases. But it's a great question, Maggie, and I don't know, in retrospect, I've kicked myself for not picking one horse and riding it, but I can tell you, we thought of about 5 other arguments we could have made. The Kirk v. Hargrave case that was the best holding, it actually was decided under an unconstitutional conditions argument. The court wasn't interested in it at all, really. Thank you.